right. My name is Katelyn Doyle. I am an associate attorney at Johns, Flaherty & Collins, and I will be talking today about estate planning. So who here has an estate plan in place? Anybody? A couple hands. All right. So a lot of people think that only very rich people need an estate plan, and I just want to say that that is not true at all. You also want to plan for incapacitation during your lifetime, and then also plan, you're not only doing yourself a favor with setting up an estate plan, but also your beneficiaries. Obviously upon a person's death, the surviving loved ones are already going through a difficult time. So if you have a plan set up and in place, you're making things a lot easier for them as well. And I don't know if anyone here has any minor children, but maybe your children have minors. So putting a guardian in place for those children is also important. So I don't know if people like to answer questions. Does anyone have an idea of what makes up their estate? Anybody?
What was the question?
What makes up your estate?
Your assets.
Yep, your assets. So we've got things like your bank accounts, retirement accounts, things like pensions, any other investment accounts, stocks and bonds, life insurance proceeds, your house, any other real estate. We're in Wisconsin, so maybe you have a cabin or hunting land, stocks and bonds, any business interests, if you own an LLC or a sole proprietorship. And then personal property, I'm sure you all have stuff at home, whether that's antiques or just your normal personal property, and then vehicles. All of that is considered to be part of your estate. So there are two main ways that your assets pass upon your death. The first is automatic or direct transfers to your beneficiaries. So this happens by using payable on death or transfer on death beneficiary designations. So at your bank or your retirement account holder, they probably at some point ask you to fill out a payable on death beneficiary designation. Those assets then will transfer directly to the person or persons named on that account. So do any accounts that are held as joint owners, and same with any real estate that's held as joint property. And then anything that passes through a trust also passes directly to the beneficiary named. The other way that assets pass to beneficiaries is through your will, which requires a probate process. So has anyone here ever gone through a probate process? Yes? Anybody else? Was it fun? No. It's really not a fun process. So it takes about 8 to 12 months to complete the process. Probate is a process in the courts. It's overseen by the Register of Probate if it's informal, or by a judge if it's a formal probate. And so, as I'm sure you know, it takes a good amount of time and a good amount of money. So in order to avoid probate, often we use those beneficiary designations, or we set up a trust. So a last will and testament is good if you want to go through a probate process and as kind of a backup to those beneficiary designations. If you don't have a will listing the people that you want to receive assets, then all of your property would pass according to the Wisconsin state statutes, law of intestacy. So basically it would just go to your closest heirs. So if you have a spouse, it would go to your spouse. If you have children, it would go to your children. If you don't have children, it would go to your parents, and then siblings, and so on and so forth. So maybe you don't want your assets to pass according to those terms of intestacy, in which case it's very important to have, at the very least, a will. So here's just a quick list of the estate planning tools that I will discuss with each of my clients, and I will go into a little bit more depth on each of these. And if anyone has a question at any time, please just raise your hand or shout it out. So a will, well, first of all, people always ask, what's the difference between a will and a trust? So let me just talk about wills first. In your will, you'll name a personal representative, also sometimes called an executor, and that is the person who's in charge of paying all of your final expenses, things like your hospital bills, funeral, those types of things, any final debts. They'll make sure that that's all taken care of. And then once all of that is done, your personal representative will distribute those assets to the beneficiaries named. So again, your will list beneficiaries, whether that's your spouse or your kids. Yes?
What do you do if you want to change something in a will?
Yes, if you want to change something in your will. So wills have very specific requirements to be valid under Wisconsin state laws. They have to be witnessed by 2 people. So if you want to update your will, if you have one in place already, you can either do that on your own or go to an attorney and ask them to update it for you. But make sure that it's executed correctly, which means that you have to sign it in front of at least 2 people. Did that answer your question? Okay, great. So we talked about if you have minor children, you would name your guardian in that. You'd state that your will, in your will, that any final expenses and expenses of administration would be paid out of your estate. And then if necessary, you could create something called a testamentary trust, which is a trust set up within your will, which is only funded through a probate process. So again, you have to open up a probate, go through the process taking about 8 to 12 months, and then that trust would be funded. So all of that happens upon your death. I don't typically recommend doing your own will just because you want to make sure that it has all of these terms and that it's executed properly so that it is a valid will upon your death and won't be contested by any beneficiaries.
Would you recommend that you have it pretty much written up and then go to an attorney to have it looked at?
Sure, yeah. So she asked if you should have your will kind of set up before going to an attorney. Yes, that's a great idea. If you have an idea of who your beneficiaries are, have a list of their names and addresses. We often ask for birthdays. We do not ask for social security numbers. We don't put those in documents anymore. It's not good practice. But
I have right now in the process of, for insurance, they have my beneficiaries and they want their name and their social security number. I don't feel comfortable asking people for their social security number.
Yeah, so life insurance companies operate a little bit differently. Often they do ask for social security numbers. I don't know if they need it in order to process all of your paperwork, but it's not uncommon for them to ask for social security
Can you
numbers.
just put down the state then and let them?
That would be a question for the insurance company directly to see what type of information is absolutely necessary in order to name beneficiaries.
We have to provide social security numbers for probate that's going on right now.
Sure, yeah. So in probates, often they'll request social security numbers, and oftentimes it's just to ensure that the proceeds are going directly to the person who should be getting those assets. So I'm just saying in estate plan documents because we keep them in our files, you keep them in your homes. We don't like social security numbers laying around. Yes?
Is there a way to avoid probate totally?
Yes, and I will get to that next. All right. Sorry, I'm just going to make one note. Sorry. No, we'll go back to our trust. So one way to avoid probate is by setting up a revocable living trust. And so a revocable living trust is a document that comes into place during your lifetime and is funded with your assets either during your lifetime or at death. So you can fund it during your lifetime by retitling assets in the name of the trust, or you can fund it at your death by just listing the trust as a payable on death beneficiary. Revocable living trusts are great if you have any beneficiaries who you want them to receive assets, but you don't quite trust them with the money, and so you want to put some restrictions in place. Maybe you have a grandkid who's 21 and in college, and maybe won't use the money for education. Maybe they'll use it for a nice party on the weekend or something like that. Or maybe you have a beneficiary who is disabled and cannot receive the assets outright because it would affect the benefits that they receive from the state or from federal programs like SSI. So a revocable living trust is great for putting those restrictions in place and for designating when a beneficiary can receive those assets. So whether that's at a certain age, maybe at an age when they are possibly more responsible, or upon the completion of a certain event, maybe after they graduate college, or complete a stint in the military, or start a new job. So you can be really creative with when beneficiaries can receive assets outright. The trust agreement also names an agent, and that is the trustee. That is the person who manages and administers those trust assets. So they have a fiduciary duty, which means that they can only use those assets for the benefit of the beneficiaries. So they can pay your final expenses, but they can't just take that money for themselves. They have to manage it responsibly for the beneficiaries named in your trust document. All right.
Question?
Yes.
The trustee could be a beneficiary?
Certainly, yes. The trustee can be a beneficiary. With people, if you have responsible children, oftentimes the beneficiary is your child who's the best with finances. You trust them the most to pay all of your final debts and then distribute those assets outright. It can be a corporate guardian if you have a complex trust. And maybe you have a bunch of taxes or tax planning that you want to take care of, and you just don't have somebody related to you who's good at that. A corporate trustee is a good option.
Can you have more than one trustee?
Yes, you can have more than one trustee. You can have co-trustees. And for all of these documents, I always recommend that you have at least one backup trustee in case something happens to your first trustee or under a will, personal representative. Always have at least one backup listed. But yeah, co-trustees, I don't always recommend it because you don't know what's going to happen after you pass away. Maybe you think your kids get along great, but crazy things happen after a death in the family. So as long as you're sure that they'll get along okay, I think it's fine, but just be cautious about it. Yes.
Do you have to put your account in the trust, or can it just be payable on death to your beneficiaries?
Yeah, so you can certainly put your accounts in the trust. The trust is just a document. If it's not funded, then it's not going to do anything. Yeah, if you have a trust, then make sure that your accounts are either retitled in the name of the trust, or the trust is a payable on death beneficiary. But you're kind of getting to the point where maybe you guys don't need a trust. Maybe you guys can just use beneficiary designations on your accounts. So to avoid probate, you can, if all of your children are grown and responsible, you can essentially accomplish most of your estate planning goals by listing your kids as payable on death beneficiaries on retirement accounts, investment accounts, bank accounts. Not everyone knows you can go directly to Ultra or Cooley or the credit union and name a payable on death beneficiary. Just keep in mind when you do that, all of those assets then do avoid probate. They're payable directly to the people listed on those accounts. But say everything goes equally to your 2 kids, then make sure they know that they are equally responsible for your debts upon your death, because then you won't have an estate to pay that money out of. Any questions about that?
Is that a tax issue also?
No. I don't remember if I talk about taxes now or later, but I'll just get to it right now. Estate taxes. Wisconsin does not have any estate taxes. So when your money passes to your children, they don't pay any estate taxes in Wisconsin. At the federal level, in 2022, the estate tax exemption amount is $12.06 million per person. So as long as you have less than $12.06 million, you will not pay any federal estate taxes either. And so for spouses, that means you have a little over $24 million that you can pass tax-free upon your death. So that is set to sunset in 2025 to $5 million per person, which still means spouses can pass $10 million upon their death without paying any estate taxes. Gift taxes, you can gift $15,000, or actually I think now it's $16,000 per person per year without paying any any gift taxes to as many individuals as you would like.
So I can gift 16,000, so my spouse to the same person.
Yes, yep, so as spouses, if you want to gift to your children, each of you can make a gift of $16,000 per person. So yeah, if you wanted to make a huge gift to your kids, you can do that. Gifts to charity, of course, are not taxed. Yes.
The payable on death, does
Yes.
that work for your house and everything?
Yes, so I think I have that later on, but let's see. Maybe I don't. So payable on death for your house, it's actually called a transfer on death deed. So that is a document specific to a piece of real estate, and you can do it for your house and for your cabin and your lake house. It's similar to the payable on death beneficiary designation on your financial accounts, but it's for your house. And so that document is recorded with the Register of Deeds. It's not a completed gift until after you pass away, so if you move, it has no effect on that. And it can always be changed. So if one of your children listed as a beneficiary pass away, you can update that. No problem. You just record it, a new one, with the Register of Deeds. $30 recording fee, not too complicated.
Okay, so I understand, I was told that you don't have a trust, you still go through probate for your house and for assets in your bank. So it's better to get a trust rather than just payable on death beneficiary.
It depends on your circumstances. So if you don't want to put any restrictions on how the assets pass, the payable on death beneficiary designations will work perfectly fine for getting those assets to your beneficiary.
And they don't have to no probate.
No probate if you have payable on death beneficiary designations. Those are contracts directly with the financial institutions that are not subject to a probate process.
So you get that through, let's say, my lender of my house. I do have to go to an attorney and get this deed.
No, for the deed, yes, that is something you should go to an attorney for. For the payable on death beneficiary designations, those are directly with your financial institutions. With the bank, with Edward Jones, with Fidelity, go directly to those financial institutions. Ask them for a payable on death beneficiary designation form. They'll give that to you, you complete it, you give it back to them. That's over here.
So you have, if upon death, and you figure you've got everything beneficiaries all listed, so you still have to, other than a death certificate, what else do you have to do to notify that the person has been deceased then?
So how do you notify the financial institutions, or is that your question?
Yeah.
Yep.
You know, if everything you've done is you've got a beneficiary for,
Mhm.
you don't have to go through probate, correct?
Correct.
So then, who do you notify about this person's death?
Sure. So who do you notify when someone passes away? So first of all, the funeral home typically is the one who notifies Social Security so that they can terminate the Social Security number. Once that Social Security number is terminated, a bunch of people and institutions get notifications that that number is no longer in existence. But in order to get payable on death assets distributed to the beneficiaries listed on them, then somebody needs to take a death certificate to those financial institutions in order to get the process started so that they can send out the paperwork, have each beneficiary fill out the paperwork, and then get the money distributed to them. Typically, they just kind of cut a check to whoever is listed in the percentage that was listed on the POD designation. Did that answer your question? Okay. Another
I
question?
had a question about, it seems like everybody's trying to avoid probate. Is there a cost to probate? I'm like, I'm dead, I don't care how long I have to be dead, 20 years, I get the money, so what?
Sure, yeah, so why should we try avoiding probate? It's really up to you. Oftentimes, it's just a gift to your beneficiaries to avoid probate. They get the money sooner and with less of a hassle. Yes, there is money involved, so you don't have to get an attorney, but oftentimes people do get an attorney to help with probate just because it's kind of a complex process, so attorney's fees. And there is an inventory fee associated as well that's payable to the state of Wisconsin or of whatever state that you passed away in. It's not a huge fee, it's a 0.02% fee, so not crazy, but you know, just another expense that you could avoid. 0.02%. But sometimes probate is good. If you have beneficiaries who are going to argue over the distribution of assets, then maybe you do want that court oversight. It doesn't always work out well to have beneficiaries listed directly on accounts as payable on death beneficiaries. Any other questions? Yes?
If I have my will and everything set up and I move to a different state, what do I have to renew?
Okay, yeah, so if you have a will set up in Wisconsin and you move to a different state, what do you have to do? If it's valid in Wisconsin, it's valid in the state that you move to. However, oftentimes it's good to at least consult with an attorney in Florida and make sure that that there's not anything you need to add to your estate plan. Oftentimes it's good for, and we're about to get into power of attorney documents, to just have power of attorney documents in the state that you move to, because financial institutions and hospitals are more familiar with those forms. All right, on my wills, I also always include a personal property list. So personal property, things like furniture, antiques, jewelry, sporting equipment. You can list specific items of personal property and then list the person to whom it should be distributed upon your death. This actually, I think, maybe 20% of my clients actually fill it out, but this could be one of the most important part of your documents, because you might not think about it right now, but those plates or that watch you have, upon your death, those sentimental items often cause the most conflict between beneficiaries. My dad likes to tell the story about my grandma. She was promised a framed statue of the Virgin Mary, but so was her sister-in-law. So my grandma gave up half of her inheritance to get that framed statue of the Virgin Mary, which is to avoid conflict in the future between your kids or your grandchildren, if there are items of not even monetary value, but sentimental value that you know somebody would want, think about putting that on your personal property list.
So, what about other relatives contesting it? They can do that.
Can other relatives
You know,
contest your will?
Payable on death to your children, but there might be other relatives that want to get involved, or
Yeah.
how do you avoid that?
Yeah. So how do you
Those
avoid?
relatives you want to give it to, so.
Right, certainly. How do you avoid having other relatives contest beneficiary designations or your wills? So beneficiary designations, they really can't contest it unless they would have some specific proof that you were you did not have the legal capacity or the mental capacity to make those beneficiary designations, which could be a problem. Maybe you have a relative in their 90s with advanced dementia, and 3 days before they pass away, they updated their beneficiary designations. That's not going to fly. So if you have proof that they don't have the legal capacity to make those beneficiary designations, that's one way of contesting those. Contesting a will would be quote unquote easier because you would do that in a probate matter. If you thought maybe one of the beneficiaries coerced that person into naming them, then that would be one option. Yes.
It's also very expensive to do that.
Yes.
Extremely expensive.
Yep. It's very expensive to contest wills. That would be paid out of that person's pocket, which, I mean, if they were successful in contesting it, maybe they would be, maybe they would get that inheritance to pay those legal fees, but it is expensive. Oftentimes, also, wills might have a no contest clause, which, so say I'm listed as a 50% beneficiary in a will. If I contest that will, then and I lose, then I would get 0% of my inheritance. So be careful with that when contesting wills. Any other questions about wills? Or yes?
Is there a time period between when a person dies and when the will has to be filed? When does it become public record?
Sure, so it becomes public record when a probate is opened. And a probate should be opened within 30 days of the person's death. It's not impossible. I've had probates opened 2 years after the person died, which isn't fun, but it does happen. Then you avoid your will having to be subject to public record. It increases your privacy. Any other questions about wills or trusts or beneficiary designations? Yes.
So, like, we have a trust in Wisconsin. My husband already has a diagnosis that he knows with that very possible that he's going to end up in memory care. So, but I'm thinking of doing it in Minnesota, putting him in memory care. So when he passes the trust, it's because I'm still in Wisconsin. Our residency is Wisconsin. Our home is Wisconsin. Is everything going to be in Wisconsin then, even though he'll pass away probably in Minnesota?
Okay, so all of your property is in Wisconsin. You're thinking of transferring him to memory care in Minnesota.
Right.
So your question is?
So is all of our paperwork valid in Wisconsin?
All of your paperwork is still valid in Wisconsin. Yes. Yep. Like I said, as long as you signed it in Wisconsin and it was valid when you signed it, then it is still valid even if you do move. Yep, absolutely. Any other questions? Oh, yep, I've got
You have a trust, but you don't have anything in that trust.
Yes.
But you have payable on death to beneficiaries.
Mhm.
That's okay, you don't have to have anything in the trust, you just have a name of a trust, but you haven't really used it.
Sure,
That's
yeah. Yep, you can set up a trust. So I'll use myself as an example. If I I could set up a trust and, I don't have kids, but I'll name my kids as the beneficiary of my trust. But if all of my retirement accounts and investment accounts have my sister listed, my kids are not going to get anything. So that's why you need to make sure that your trust actually has assets in it by using either retitling or the payable on death beneficiary designations. Otherwise, you just spent a few $100s to set up a trust for no reason.
But if it's on table on death, then it's okay that you don't have to name the trust, right?
Right, you do not need a trust. Yep. Yes.
I learned the term first trip up.
Yep.
I love it.
Yep.
And but the problem here is I want to leave my money to my siblings for strip up. And one of my siblings has died already. Can I put his name down and they can figure out who his descendants are? Or do I have to go, okay, Joe, John, so how much do I have to designate?
Sure. There's a term that we use for STRPs, also sometimes referred to as by right of representation, which is a term used to describe how assets pass if one of your named beneficiaries predeceases you. So say you listed your siblings as your beneficiaries by right of representation or for STRPs, which means that it passes along the bloodlines. So if one of your siblings predeceases you, then his or her share would go to their children, which is a really nice way to make sure that your money goes to someone without having to list, 50 beneficiaries or something like that. So as long as you're okay with your nieces and nephews getting that whatever percentage share.
In the line.
Yep.
And even though my brother is dead now, can I still put his name down as the person and they'll have to figure out who all his kids are?
Certainly, yes. Yep, if you're fine with them just taking care of that, then you can go ahead and list them as beneficiaries for certain. Yep. Any other questions? All right. Then we'll get into power of attorney documents. Power of attorney documents are a great way to plan for your incapacity during your lifetime. So incapacitation would be something like you're in a coma, you have advanced dementia, or you're otherwise unable to make financial or medical decisions for yourself. With a power of attorney for finances, it allows you to name an agent to make financial decisions for you during your lifetime if you're not able to do so. So somebody who could pay your bills for you, if you moved into a nursing home, someone who could sell your house for you. Name a person that you trust to make those financial decisions for you.
I've got a question.
Yeah.
But that doesn't take effect until you are incapacitated, right?
So there are two options. Your financial power of attorney, you can either specify that it becomes active upon your signature, in which case you would just give a copy of that document to the person that you named as your agent, and then when they either if you ask them to start paying your bills, and it doesn't have to be during incapacitation. Maybe you go on a month-long trip and want them to pay your bills while you're gone. It can take effect at that point in time. Otherwise, they would just have a copy, and when they're notified that you're unable to make your bills or make financial decisions, then they would start acting then. Otherwise, you can specify that power of attorney document does not come into effect until you are declared incompetent. And so that would require two doctor's notes, or a doctor and a physician. All right. So then we also have power of attorney for healthcare. sometimes called an advance directive. You can get those directly at Mayo or Gunderson or the VA. These documents, similar to financial power of attorney, allow you to name a healthcare agent to make your healthcare decisions for you if you're incapacitated. These do require a determination of incapacitation by 2 physicians or a physician and a psychologist. But again, these documents, the advance directive at Gunderson and Mayo have several parts to them. First, you decide who your agent or agents are. Again, I always recommend having at least 1 person and 1 backup. And then you also decide what decisions your agent can or cannot make for you. So can your agent admit you into a nursing home? If you say no and you have to go into a nursing home, that's going to require a guardianship proceeding. So just keep that in mind. Can your agent decide to quote unquote pull the plug? And then, I don't know if this is applicable for anybody, but can your agent make decisions for you if you're pregnant? So then the next part is a declaration to your physician. And this just lets your doctors know what your decisions are regarding your care. So do you want life-prolonging treatment? Things like feeding tubes or a respirator, would you want to be put on those? If you're in a certain condition and that condition is you are unlikely to recover from your condition in order to know who your loved ones are. And then, do you want CPR? That's another, yep.
If you change your agent or add a co-agent, do you need to redo the whole thing or just?
Yeah, do you need to redo your entire healthcare power of attorney if you change your agent or add a co-agent? Yes, Gunderson and Mayo do not require that you update the entire thing. They are no longer accepting amendments to those power of attorney documents. But again, you can get those directly with your healthcare provider free of cost. Just fill it out at the hospital and they'll put it into your medical records for you. The last part of the advance directive asks whether you want to donate any organs and whether you would want an autopsy. Again, it's important to talk with your agents, whether that's under your will or your trust or financial power of attorney or healthcare power of attorney. Discuss with them what your wishes are so that if these events do take place, they know what you want to have happen. And they're not just surprised that all of a sudden they're named as an agent to make these huge decisions for you. It's super important to have these conversations with these people. We talked a lot about beneficiary designations already. Does anybody have questions about those? All right. So another document that you can put in place is an author's. You have a question?
On the last one, I have to get different stories. If you want to put, again, your house and your assets, your bank accounts, does it make a difference if you put with your spouse and when put before? Is there a difference?
Yeah, so does it make a difference if your assets say and or when it's listed as joint property with your spouse? Yes. If it says and, then both of your signatures are required to, say on your car, both of your signatures would be required to sell it. If it says or, then you could sell it without your spouse's signature.
So does that matter? My husband has the dementia now, so do I have to have that changed?
Well, if it says and, he would have to sign off on it, and if he's already past the point of being able to make legal decisions, then it's a little bit too late to do that.
So that can be hard. Because it's and I'm already power of attorney for both finances.
If you're power of attorney, then you've taken care of it. then you can sign off on that as his agent.
Great.
Yep. All right. Any other questions? All right, then we've got an authorization for final disposition is another document that you can have in place. Not necessary, but I recommend it if you think any children will disagree on how your body should be taken care of upon your death, or if you just want to specify any funeral arrangements that you want to have in place. So if you can list funeral arrangements and your preferred bodily disposition, whether that's burial or cremation. Finally, oh, yeah.
I have a question. I just prepaid for a cremation.
Sure, yeah.
But do I put that in my will that, because the person that signed off on the, I prepaid to said, make sure they know that you did this so they don't go off and pay for another funeral somewhere else.
Sure. Yeah. So how do you make sure your agents are aware that you have prepaid for your funeral? We don't put it in our wills. Some people do. What I just say is keep all of those documents in one place. And you actually, that's a perfect transition. This comprehensive list that I was about to talk about is something where you would list all of the documents that you do have, so your will or your trust. You list all of your financial accounts and where to find them. You can put the account numbers on them. And then on this, you would also list that you have a prepaid funeral, those types of things. So that all of that important information is in one place. Also, a good option for that is to put all of your like electronic accounts, your Facebook or your email. Email is probably the most applicable here, and the passwords to get into those accounts. Your online bank accounts, put all of that on there so that people can access that upon your death. Tax considerations. I already said that we don't have to worry about estate taxes, but there are other tax implications at play with inheriting versus gifting. So I always use the example of a house. I actually just talked to someone this morning who bought their house in 1976, I think, for $26,000. Today it's probably at least triple that. So if she gifted her house to her kids, they would inherit what's called the initial tax basis in that house. So the kids, if they received that house during their mom's lifetime, would have an initial tax basis of $26,000 in the house. Say that they wanted to sell the house today and it's worth $126,000. They would then have to pay a capital gains tax on that increase in value of $100,000. Capital gains taxes are around 40%, so it's going to be a lot of money that they're going to pay. This is a huge problem in Wisconsin for people who receive farmland as a gift during their parents' lifetimes. You don't want to be paying a gift, or you don't want to be paying a capital gains tax on an increase in value of millions of dollars, because now that farmland is developable and worth millions of dollars. So just something to keep in mind. That is something that you need to consider if you're gifting your house to kids to avoid it going to the nursing home. So for Medicaid planning, just keep that in mind, that if you give your house to your kids so that Medicaid can't take your house, capital gains taxes might be an issue for you. If instead yes.
If they gift it,
Yep.
then you don't have to pay the capital gains?
Nope, if you gift it, then your kids receive your initial basis in that property. So your initial basis is the value at which you purchased that property.
The $26,000.
The $26,000 is your initial basis, and it's the basis that your kids get if you gift it to them property, upon your death, they get what's called a step up in basis. So if you die today and the property is worth $126,000, then your child receives that step up in basis to $126,000. So that if they sell it a month after you die, they will pay 0 to a very minimal amount of capital gains taxes. Does that make sense? It's a little bit complicated. I know math is not my strong point, so if anybody has questions, but...
Say the last part of it again. They inherit it, and then what happens?
If your kids inherit anything from you, they will get a step up in basis to the value of the property on your date of death. So if it is now worth $126,000 in 2022, the year that you die, that is your children's inherited tax basis. Yep.
So it's better to gift than inherit?
It's better to inherit than gift. Yep. All right. And
Gamble that you're not going into a nursing home.
what's that?
But you gamble that you're not going into a nursing home
Right.
because they're entitled to get their cost.
Right. Yep. So I can give a short overview of Medicaid planning. It's really complex, so I'm not going to talk a lot about it. But oftentimes people are concerned about Medicaid planning in case they need to go into a nursing home. In order to qualify for Medicaid, you can only have $2,000 in countable assets. So you have to be kind of on the threshold of poverty in order to qualify for Medicaid. Once you qualify for Medicaid, the state starts paying for your nursing home care. And yes, upon your death, Medicaid or Department of Health Services can initiate an estate recovery process where they kind of make a claim upon any assets up to the value of services that they provided during your lifetime. Yes?
I heard that if you have a house, if you sell it 5 years before you go into the nursing home, then they can't touch your home.
Sure. Yep. So there's a 5-year look-back period. Medicaid will be looking at any divestments that you made during your lifetime, and they will look back 5 years from the date that you qualify for Medicaid. So 5 years from the date that you have $2,000 in assets or less to see if you made any divestments. A divestment is the transfer of property for less than fair market value. So that can be a gift, or it can be a transfer of property into an irrevocable trust, both of which are options that people use for Medicaid planning to protect assets. So 5-year look-back period if you're making any big gifts or any transfers of property into irrevocable trusts.
But if you make those gifts, that whoever pays the capital gains, right?
Yep. So yeah, that's a tax issue, not a Medicaid planning issue, which obviously work hand in hand, two considerations to make.
Can Medicare go against, like insurance policies that maybe have beneficiaries and stuff on your death?
Yes, they can if those life insurance policies were purchased after 2014. There was an update in the laws. So if you purchased the life insurance before 2014, then you're good. But if it was purchased after 2014, then it would be subject to estate recovery. All right. So yeah, Medicaid planning is really complex. If you have any other questions, I'd be happy to talk to you about it later. I always just like to include charitable giving on my PowerPoint. We're here at the public library, so I'm sure they would love to receive a gift upon your death. Again, you can have tax advantages to making charitable gifts either during your lifetime or upon your death. But just keep that in mind that you can list charities as beneficiaries on like retirement accounts. Since charities don't pay income tax, then that would be a good tax planning option, listing a charity as a beneficiary on IRAs or other pre-tax accounts. All right, and then I always also recommend that you have a well-rounded estate plan and a good number of professionals to ask any of these estate planning questions or tax questions to. That includes your insurance agent, a financial planner, an accountant for tax purposes, and then of course an attorney. So, any other questions? Yes?
If you have a revocable living trust, is it expensive if like one person that's listed on the trust passes away? Is it expensive then to proceed with whatever needs to change in your plan?
Yeah, so is it expensive to update your revocable living trust upon the death of a spouse? It shouldn't be. Typically attorneys work on an hourly basis, so it would kind of depend on what types of changes needed to happen. If any, maybe your revocable trust has contingencies in place, well hopefully it does, with the attorney who drafted it planning for the death of the spouse. So maybe you don't even need to update it. But if you do, then it shouldn't be too expensive to add an amendment to that trust to make sure it's up to date. Maybe you want to add a trustee as a backup or something like that. So yeah, hopefully not. Yes?
Do joint accounts, do they go to the probate?
No, they don't. Good question. Joint accounts pass directly to the joint owner upon the first joint owner's death. Same with houses that are held jointly or held as husband and wife survivorship marital property. The house will pass directly to the surviving spouse then.
So like investments in that.
Investments, yep,
They will all go to that.
exactly, yep. One thing to keep in mind with joint accounts, often people list children as joint owners. If you have, say you have 3 children and you listed your daughter as a joint owner so that she can help you pay your bills during your lifetime, that account does pass to the joint owner, so it would go directly to that daughter and not to all 3 kids. So just be aware, I know a lot of people do that for ease of paying bills during your lifetime, but a financial power of attorney accomplishes the goal of having a child help you pay your bills without making them a joint owner of that account. Yes?
So after his trust, so after he passes, try to retitle the house in just my name.
Is it
Title
titled?
trust now, when he passes.
Yep.
So it'll go just to me as the sole owner in the trust,
Sure, yep, and you can keep it in the name of the trust.
even though he has passed.
Yes, certainly, yep, if it's a joint revocable
So I
trust.
have to do a quick deed.
No, you don't have to, as long as the terms of your trust still accomplish your estate planning goals. If you wanted to, you could take it out of the trust and put it in your name, but since you have the trust there, no point in changing it as long as you still have the proper beneficiaries listed in that trust. Yes?
Do you have to have a certain amount of money related to have a trust? It's okay just to have a will with your beneficiaries, stable on that?
Sure, yeah. So you do not need to have a certain amount of money for a trust. You can put, however, you can put your house in a trust, you can put your bank account in a trust, you can put whatever you want in a trust. But I think your main question is, do you need a trust? And the answer is no. You can accomplish your goals using payable on death beneficiary designations and your transfer on death deed for the house, as long as you are good with those assets going outright to your beneficiaries. I do still recommend that you have a will in place to name a personal representative to take care of your final expenses upon your death. And then to act as a backup in case you have any accounts that you forgot about. And then, of course, to govern any property that doesn't have a beneficiary designation. So things like cars and personal property where you don't, you can't put a beneficiary designation on those assets. So say you just want everything to go outright to your 2 kids, you just list your kids as equal beneficiaries on your bank accounts and retirement accounts and investment accounts. You have a simple will saying, I want everything to go equally to my kids, and you list your personal representative, and that can take care of your estate planning if that's what your goals are. Any other questions? Yeah.
Going back to this gifting. Yeah, I purchased my house at $10,000.
Yep.
And along this pathway, I put an addition on the house, the value of the house increased considerably, but still on this gifting, do you go back to the 10,000 or does it have to be reevaluated because of the upgrades that you did to it?
That's an excellent question. I would say talk to your accountant about I am not sure if your initial basis would be the purchase price or if it would include those brand new additions. If we have any accountants, you can answer that question. Any other questions? Yeah.
Just to be clear, that if you have a will and nobody contests anything, then it would not go to probate, right?
No, that is not correct. So anything that passes through your will does have to go through probate. In order to avoid probate, you use those beneficiary designations on your financial accounts or a trust. But say you have a bank account at Cooley, you go to Cooley and ask them for a payable on death beneficiary form, and they will give that to you. And that is a contract directly with the financial institution that allows your assets to pass directly to the person named as a payable on death beneficiary. So if you don't have anyone listed on that account, then that is subject to probate and would pass according to the terms of your will. Does that make sense?
So all your assets you have that form filled out, like even like life insurance and all that too?
Life insurance definitely should, yep.
So what if there's a spouse in there? Do you want, I mean, you've got 4 kids, spouse and 4 kids, so do you want your kids?
That's a great question.
Payable on that?
Yeah, so payable on death should have a primary beneficiary, which in most cases is your spouse, and then it should have a secondary or contingent beneficiary, which would then be your 4 kids, if that's what you want. Or if you disinherit one of your kids, then it'd be your 3 kids, I'm just not saying that about you, just for example. And in that case, so if you are disinheriting one of your kids and you list 3 out of 4 of them, again, really hard to contest that if you're using a beneficiary designation, because again, it's a contract directly with the financial institution. But yep, primary beneficiary, contingent beneficiary on all of those accounts. Yes?
So, okay, when your spouse passes and he's on Medicare disability or just straight Medicare and Social Security, so they want that payment back whether he passes the 1st or the 18th or the 30th. You have to send that. You send the whole payment back, or how does that work?
They typically prorate it, I believe.
It is. See, I was thinking it was the whole month.
You should talk directly to, like, social workers would be able to tell you that. Yeah, I'm not talking about Medicaid and those types of things,
Right.
or Medicare. Medicaid is a separate program,
Right.
based on needs. This is separate. Yep. Any other questions? All right. Well, you guys have been great. Really awesome questions. If you have anything else, please come to me afterwards, and I'd be happy to answer anything else that you guys might have.